Much. When Dr. David Macklis, the vice chairman of the International March of the Living, brought us all together to think about how we could impact future education, how we could develop a curriculum, how we could incentivize people to learn from the past in order to avoid the ills of the past in creating lessons for the future. One of the developments brought together John Barrett, John Farmer, Paul Miller. John Barrett, you're going to hear from at lunch. This continuing legal education program has a name, and names, as we saw yesterday, as we heard yesterday, mean a lot, because every person has a name. Those who came through and were tattooed with a number became a number. The survivors still alive who proudly hold up their arm and show their number weren't so proud, weren't so willing at the beginning. They hid their arms, they hid their faces, and they hid their stories. What has enabled them to talk about the past is the rule of law, the application of the rule of law, and a justice society that has encouraged talking about the past in the context of learning for the future. Professor Barrett will tell you about Justice Robert Jackson. And he essentially is the namesake for this program. Because what Justice Jackson did is stand up as a lawyer and a justice at Nuremberg to see to it that lessons could be taught, but more importantly, to create accountability. It is unfathomable what humanity did to humanity. My friend Michael Basler, an esteemed professor of the Holocaust law and justice based at Chapman University, and I met recently and we talked about this session. And he sent me a note afterward where he said, apropos to our discussion about law and the Holocaust, see the comment below by the late law professor Ted DeCoste of the University of Alberta. He died last February, but his statements below are spot on. Holocaust education, as it is generally pursued in high schools and in undergraduate arts and science programs, portrays the Holocaust as a lawless event that was perpetrated by pathological monsters, says Professor Ted DeCoste. Quote, that happens not only to be true, it could not possibly have been true. Pathological, hate-filled barbarians cannot accomplish what the German state accomplished in the Holocaust. The Holocaust was not a pogrom, and I continue the quote. It was rather a constitutional commitment and program of a sophisticated constitutional state, unquote. Professor Basler continued, the truth of Auschwitz, the largest of Nazi Germany's concentration camps and extermination camps where more than 1 million Jews were killed, is that, quote, it was a creation of law. It was lawful. It was full of law, end quote. When talking about the role of law in the Holocaust, DeCoste also notes, quote, it falls to law schools to deal not only with the happy patrimony of the law, but with the law's history of political evil as epitomized in chattel slavery, the subordination of women, and as here the Holocaust. That is to say, law schools should teach not only the law's goodness, but also its baleful history and potential. And the best way of doing that is to interrogate the law's primary and essential contribution to the legalized murder of people by a modern constitutional state, and indeed by the preeminent state in Western Europe. So viewed, DeCoste went on to point out, and I conclude this point with this quote: "The law is not just a central historical fact of the Holocaust. The Holocaust could not even have been conceived without law, nor without lawyers." End quote. When people hear the word Nuremberg, they don't think so much about the city in Germany. When they hear the word Nuremberg, they presume it's about the Nuremberg trials. But the Nuremberg trials was the aftermath. The Nuremberg trials was the beginning of the holding of the accountability phase. Let's look for a few moments at what led to the Nuremberg trials. Let's look at the beginning, the Nuremberg laws. In 1933, the government of Germany enacted laws. How they were put together, the role that Hitler played personally, his ministers, who he selected, Jewish advisors, other advisors, in order to put together a text that could be presented to the government, presented to the party. He knew it would be rejected, so it was a pronouncement, but it got a lot of things. It got applause, it got encouragement, it got involvement, it got commitment, it got loyalty, and it moved to things we even hear today. We hear about boycotts. We all know about the boycotts of South Africa and how, because of apartheid, South Africa was brought to its knees by a boycott. But the modern approach to boycott today addresses issues relating to accusations and allegations relating to Israel's involvement and treatment of Palestinians in the West Bank, and a campaign using law today to boycott today, whether based upon truth, whether based upon fiction. The law is being used. Harken back to 1933, and it was the boycotts of Jewish businesses, supported by law, supported by the police, supported by government, and not opposed by the lawyers, that led to, quote, a legalization of hate, unquote. How did it do so? Well, there is the court, and the courts enforced shutting down businesses. There is the police, and the police made sure that the barricades were up. There were the police, and the police made sure that the defamation on the windows of the Star or of Jude or of "don't shop here," using whatever words that were used, that was all not only permitted, it was encouraged. Take it one step further. Shops closed, people's homes shut, confiscated, people transported away, relocated to ghettos, relocated onto trains for the fancy word of deportation, transport to concentration camps, transport to death and extermination camps, use of people in forced and slave labor. All of this wasn't just government created and government enforced and government encouraged, but the translation of that enforcement and encouragement moved over to embody the court of public opinion. And just like today, when somebody wants to get something done, whether it be in the Ukraine, whether it be in the United States, whether it be anywhere else, there is an approach to public opinion. We heard from John Farmer, we heard from Paul Miller, we've heard we know from David Macklis, that the use of public opinion is an important tool. The citation to the New York Times article about the need for Holocaust education, the lack of understanding, is very, very important. But the fact of the matter is, it took the government, the arms of government, the police, and it took civil society in order to enable the platform for the legalization of hate. Where were the lawyers? Well, many of the lawyers were judges. Many of those judges followed the path of the government. Many of those judges were thrown out of office. The lawyers themselves had the opportunity to initiate proceedings, to become public advocates in the court of public opinion. They were shrinking violets. They disappeared. There was very little resistance by the legal community, the total legal community. Judges became enforcers of the policies of the government. And there is where we have a divergence. Because if in the legalization of hate, anywhere in the world, then or today, if government policies, right or wrong, are simply applauded or applauded by silence, what you end up with is a dastardly situation. Because if we, the lawyers, don't stand up, if we, the lawyers, don't speak out, if we, the lawyers, don't teach, don't encourage others to learn, if we, the lawyers, don't take people by their hands to see the facts, the bricks on the ground, the mortar, the buildings, the canisters of Zyklon B, the gas chambers, the showers, the way people were separated, one way for life, another way for death. It became a machinery that was just part of the war, but for the Nazi Germany government, it was a central mission, the annihilation of a people. The annihilation primarily of the Jewish people, but the annihilation of other peoples as well. It's told that 6 million died, but through the work of the U.S. Holocaust Memorial Museum, Yad Vashem in Israel, and lawyers working together, a few years ago, now a little more than 10, there was uncovered in Germany at a place called Bad Arolsen, records. Those records were in a place that was a depository by the Germans themselves, and after that by the Allied forces, of all records amassed. And those records were put under the International Committee for the Red Cross. They had a contract with 11 governments to administer the records. If you filed a request about a family, a father, a grandfather, a grandmother, a sister, years went by before you'd get any information. Through the work of the International Tracing Service, those records were opened up. Those records have now been digitized. And what have we learned? We have learned that the methodical tracing of people occurred during the Nazi regime. And that methodical record tracing has provided evidence today that we didn't have 70 years ago at the Nuremberg trials. What those records show is how a certain, each individual named person was taken, transported, maybe taken to a hospital and had surgery, maybe put on a transport, maybe deleted from a transport, maybe moved to this camp. Some people moved to 8 or 9 camps because they had little hands and they could work, or they had little feet, or they could climb into places and be used for labor. 6 million died. The records of the International Tracing Service now include more than 100 million documents, digitized and available as evidence for we lawyers to help the public and families understand the truth of what occurred. One of the things that we know is more than 17 million people were killed, displaced, or otherwise had their lives destroyed. All of that occurred by government acts. The Nazi government that had a big war plan, a big takeover plan, but it wasn't just about land. It was about the decimation of a people, the attempted annihilation of the Jewish people, a resolution of what they saw to be a final question. Things discussed in treaty-type meetings, like at the Wannsee Conference. Things discussed here and in and there. Many of the people who participated were lawyers. Where were the lawyers? The lawyers shamefully wilted. The lawyers shamefully did not stop the enactment of law. Maybe they felt incapable, but the fact of the matter is they were capable of doing more. And we are capable of doing more, but only if we learn the lessons of history and follow the leadership of Justice Jackson, and that you will hear from John Barrett and John Farmer and David Macklis and Paul Miller. Following their leadership is what has brought us here today to begin the discussion, the learning of how is it possible that there was the enactment of the Nuremberg laws that resulted in such atrocities, the burning of books and of synagogues and the shooting of people in their head or their back and while they were holding the hands of their children. How is it possible? It became possible because of the bastardization of the law itself, the misuse of the law, and the failure to recognize that we have an obligation of accountability as lawyers in 1933 and 34 and 38 and 39, and to have stopped Kristallnacht, to have stopped the burning of all those synagogues, to have become the public advocates. We, as a profession, wilted. We failed. And only when the Nuremberg trials themselves began, and under the forceful leadership of Justice Jackson, did law and accountability for the Holocaust begin to take on a respect that has set standards today for international law, international human rights law, and created the concept now embodied in the law of genocide. We gather here in Krakow. We gathered yesterday in Auschwitz and in Birkenau with a common commitment to stand up, to speak out, as lawyers, to not only be proud, to not only be forceful, to not only be wise, but also to remember the lessons of the past, and to remember that each one of those people who perished had a name. Thank you.